that I'm going to discuss is Exclusion of Evidence Telephone Taps by Michael Bolander, and it's from the Journal of Criminal Law. So in this article, the author begins the article by citing two court cases based on drug charges where wiretaps were used to gather incriminating information through phone conversations. The evidence obtained from the wiretaps were used to send the accused to prison. And upon appeal, the defendant stated that the wiretaps used to incriminate them violated their rights of privacy. And the article goes on to discuss how evidence acquired fraudulently through wiretaps can be considered inadmissible in court because it's seen that the evidence is contaminated. And the author discusses the exclusionary rule and points out when evidence will not be excluded because the rule doesn't apply in some instances. The article ends with explaining why the court's ruling was unacceptable because the evidence was quote-unquote contaminated, which calls for an appeal. The point of this article is to conclude whether or not evidence obtained from a wiretap that was secured under illegal means should be admitted into evidence or excluded because it violates a person's right to privacy. By addressing the Fourth Amendment, various court proceedings, exclusionary rule, and the good faith exception, the author makes a point to add that wiretaps are to be conducted when all other resources are exhausted, because wiretapping is intrusive and it can be seen as a violation of one's rights. So this source is useful in my research because it focuses on situations where wiretaps were used to gather information under illegal methods. And the article emphasizes why the evidence obtained was inadmissible under appeal. The key question raised is whether or not the evidence used could put someone away for a crime committed. Is it right to say that it's an invasion of privacy if it can convict someone of doing something illegal? I plan to use this information in my research because it's going to help me answer the question of, is there evidence from a wiretap that can or cannot be used in court? So that's why this article is important to my research, because it'll help me answer that question. So the last one that I'm going to discuss is how the U.S. Patriot Act will permit governmental infringement upon the privacy of Americans in the name of intelligence investigations. This one is by Sharon H. Rockwell, and it's from the University of Pennsylvania Law Review. The first part of this article begins with a discussion of September 11th, 2001. When the terrorist attacked NYC and the efforts made to ensure that this kind of attack never happens again, and Americans' views on their civil liberties, and how many Americans were willing to give up their civil liberties if it would stop terrorist attacks from happening ever again. The article goes on to discuss the Bush administration and the ability to access the tools needed to intercept terrorist activity. The new laws brought up, and new laws from the Bush administration brought up the question of would it violate civil liberties. So the Patriot Act came about under the Bush administration because there was a constant pressure to make things happen, and with the Patriot Act it made it easier for the lives of law-abiding citizens to be intruded on. The article produced the views of the Civil Liberties Union, and they felt that there were some parts of the bill that they agreed with, but they felt that it gives the Attorney General and law enforcement agencies the ability to violate civil liberties because of the new powers granted under the Patriot Act. The next section of this article focuses on the First and Fourth Amendment and how prior to September 11th, we as people were once protected. There's a review on what both amendments are and how they are supposed